evening, everyone. We might have some people coming in a little bit late, and I think there's plenty of room. And I'm so excited that you're here. My name is Sam Kaplan. I'm the director of the Center for Jewish Studies here at UNC Asheville. If you could please silence your phones. I wanted to alert you that the event is being recorded tonight, so if there's something that is said and later you're thinking, what was it that she said that was so amazing? You'll be able to find it. This will be part of an archive of videos here at UNCA. And there will be a question and answer period at the end of the event, and we'll be using the microphone you see in the middle aisle. I appreciate that you have chosen to spend this evening to attend the annual Phyllis Freed Solid Memorial Lecture. This lecture is named for Phyllis Freed Solid, who was an active and vivacious member of the Jewish community, socially minded, and took on many leadership roles. The lecture is made possible by an endowment established by her husband, Dr. Norman Solid, to bring a nationally known Jewish scholar to our campus. And we're fortunate tonight to have Phyllis Solid's daughter, Lisa, and granddaughter, Kayla. If you want to wave, welcome them, give them a warm welcome. They came all the way from South Carolina to be with us tonight. This year, the scholar is Dr. Lisa Jaffe. She is currently serves as the Shulamit Reinhardt's director of the Hadassah Brandeis Institute, possibly the only institute in the world focused on women in Jewish studies. She holds 3 law degrees from Osgood Hall Law School and Harvard Law School. She has served as a law clerk to Justice, is it Iya Kabuchi? Okay, just like we rehearsed. The Supreme Court of Canada, and was called to the bar of the Law Society of Upper Canada. She joined the Hadassah Brandeis Institute in 2007 to establish a project on gender, culture, religion, and the law, which she continues to direct. She's an expert on women's rights under Jewish family law, and her research focuses on the intersection between secular and religious family law. Some of her publications are Gender, Religion, and Family Law, Theorizing Conflicts Between Women's Rights and Cultural Traditions, The Polygamy Question, Women's Rights and Religious Law. She's currently the editor of Brandeis University Press series on gender, culture, and religion and law, and the law, and associate editor of the Hadassah Brandeis Institute series on Jewish women. She's a co-founder of the Boston Aguna task force devoted to research, education, and advocacy for women under Jewish family law. And we are honored to have her on our campus. Please give her a warm welcome, Dr. Jaffe.
Thank you, Professor Kaplan, and thank you to the Solid and Fishbane family for welcoming me and allowing me to honor your mom in this way. So, American Jewish denominations are rarely in agreement really about anything. 2 Jews, 3 opinions. I know you know this story because I had a tour of Asheville this morning and I learned about the creation of the one shul and then the other shul. So I know you know that story. And yet, after the Supreme Court decision in Dobbs versus Jackson Women's Health in the summer of 2022, Jewish groups from across the denominational spectrum responded in statements that they released in surprisingly similar ways. So I'm going to read to you a selection of them, sort of moving from the progressive to the most orthodox. The Central Conference of American Rabbis of the Reform Movement said, "The Dobbs decision violates the First Amendment's guarantee of the right to free exercise of religion for Jews and others whose religious traditions, like ours, permit abortion." The Reconstructionist Rabbinical Association said, "We have long held that the choice to end a pregnancy must remain in the hands of pregnant individuals in consultation with their doctors, loved ones, and religious advisors. Jewish tradition itself not only permits, but sometimes requires the ending of pregnancy when the pregnant individual's life and well-being are in jeopardy." So we're moving along the spectrum. The Committee on Jewish Law and Standards of the Conservative Movement said, We affirm the right of pregnant people to choose an abortion in cases where the continuation of a pregnancy might cause severe physical or psychological harm, or where the fetus is judged by competent medical opinion as severely defective. This position is based on our members' understanding of relevant biblical and rabbinic sources, which compel us to cherish the sanctity of life, including the potential of life during pregnancy, and does not indicate that personhood and human rights begin with conception, but rather with birth. Rabbi Yonah Rice, the Rosh Yeshiva of the Rabbi Isaac Elkanan Theological Seminary at Yeshiva University, which is the flagship of American modern Orthodoxy in New York, gave this response. He said, "I think our main concern as Jews must be that we be able to practice our religion freely. There is no right to abortion in Jewish law, but there are cases, such as when a mother's life is in danger, when an abortion is unfortunately necessary. And there are other cases, depending upon the stage of pregnancy and the medical or psychological issue in question, when a rabbinic authority might rule that an abortion is permissible. Legislation and court rulings, federally or at the state level, that absolutely ban abortion without regard for the health of the mother would literally limit our ability to live our lives in accordance with our responsibility to preserve life." Now we get to the more extreme Orthodox positions. The Orthodox Union, an association of centrist Orthodox synagogues, said, "We are unable to either mourn or celebrate the U.S. Supreme Court's overturning of Roe v. Wade, but we cannot support bans on abortion at any time, at any point in a pregnancy that would not allow access to abortion in life-saving situations. Similarly, we cannot support legislation that does not limit abortion to situations in which medical, including mental health professionals, affirm that carrying the pregnancy to term poses real risk to the life of the mother." Even Agudat Yisrael, an ultra-Orthodox advocacy group operating under the auspices of the Council of Torah Sages, welcomed the overturning of Roe, but concluded their statement with a caution. "To be sure," they said, "there are certain extraordinary circumstances where our faith teaches that a woman should terminate her pregnancy. Agudat Yisrael fully supports her right to abortion in such situations, both as a matter of constitutional free exercise and moral principle. However, it must be reiterated that these cases are indeed extraordinarily rare exceptions to the rule that fetal life is entitled to protection." So from these statements, all released after the fall of Roe, we can see that while there are some variations in approach, there is widespread agreement across Jewish denominations on a few facts. Jewish law permits abortion. Jewish law sometimes requires abortion. Jewish law understands abortion to be a form of health care, necessary in some situations to preserve maternal life or health. That Jewish people have abortions for a range of reasons. Some do this in consultation with and with the support of their clergy and their co-religionists. And everybody, from the most liberal to the most orthodox, from the pro-choice absolutist to those who rejoiced at the fall of Roe, was worried. They share a worry that the kinds of abortion limits or outright bans that have sprung up across the U.S. since the Dobbs decision might prevent women from any denomination from having abortions that Jewish law and ethics find acceptable or mandatory. So in my lecture this evening, I'd like to explore with you the basis for this perhaps surprising consensus amongst clergy across the Jewish spectrum, that Jewish law permits or requires abortion in at least some circumstances. I want to do this by looking at classical and modern sources. I want to show areas in which there is widespread agreement, areas where interpreters from different denominations part ways, and how these principles are being deployed by Jewish individuals, groups, and clergy in legal challenges to abortion bans that are working their way through the courts. I'll conclude by identifying some new interpretations of Jewish law offered by those who can and have experienced pregnancy, which suggests that a central principle of Jewish approaches to reproductive rights is to trust women and their understanding of whether they can proceed with pregnancy. So let's start with the foundational biblical text that guides Jewish understandings of the significance of maternal and fetal life. And it's found in Exodus or Shmot chapter 21, which says, "When men fight and one of them pushes a pregnant woman and a miscarriage results, but no other damage ensues, the one responsible shall be fined according as the woman's husband may exact from him, the payment to be based on reckoning. But if other damage ensues, the penalty shall be life for life, an eye for an eye." The plain meaning of this text, according to Jewish interpretations, is that there's a difference between an accident that causes the loss of a pregnancy and one that causes the death of a pregnant person. If the assault causes the loss of a pregnancy, the punishment is to pay damages from the perpetrator to actually the father, because the loss is significant and needs to be compensated through monetary damages at an amount to be negotiated between the parties. If, however, the assault causes what the text describes as other damages, which we understand in Jewish tradition to be the death of the mother, it's a capital crime, punishable with the loss of the perpetrator's life. So in Jewish interpretations of this text, there's a clear contrast between the status of the fetus and the status of the mother. The reduced consequences of monetary damages for ending a fetal life have been interpreted by the rabbis in our tradition to mean that a fetus is not a full human life. Jewish positions on the permissibility of abortion flow from this basic premise, that a fetus is not a nephesh, a human life with the rights of a living person prior to birth. It is, however, a potential life, something of value, to the parents and the community, and should not be terminated lightly. So the rabbis go on to ask in the Talmud, if the fetus isn't a human life, what is it? In Yevamot, Rav Hizda said, if she is pregnant until 40 days from conception, the fetus is merely water. It's not yet considered a living being. And some interpreters in Jewish law take this to mean that there's no prohibition on abortion or the destruction of embryos prior to about 7 weeks from the last menstrual period. And this indeed is how in vitro fertilization procedures are thought about in terms of Jewish law and in the law in the state of Israel, that prior to 7 weeks they can be destroyed. Some authorities say the embryo has a soul of some kind from conception, or some say from 40 days from the last menstrual period. But it's important to know that although Judaism has a notion of the ensoulment of the fetus, it doesn't play an important role in thinking about the permissibility of abortion. In her 2001 tshuva, or opinion for the conservative movement, Rabbi Susan Grossman said, one of the most important distinctions between Catholic canon law and rabbinic law is that the rabbinic view of ensoulment, of when the soul enters the body, does not translate into a juridical definition equating an ensouled fetus with a human life. Until it is born, a fetus is to be treated as part of the pregnant person's body. This is illustrated in a number of situations in the Talmud where the rabbis have to decide questions about how the status, changes in status of the mother affect the status of the fetus, and vice versa. I'll just share the most well-known one. The rabbis ask in Gittin 23b, if an enslaved woman is told by her master, this is a very different world that they're speaking about, if she's told by her master that when her fetus that she's carrying is born, it will be free, is she herself freed along with it? And the rabbi's answer is a clear yes. In freeing the fetus, which is part of her, the master is also freeing her too. A fetus, they say, is considered like the mother's thigh, a part of the mother's body. He cannot free her limb without freeing her as well. So we know a few things about the fetus in Jewish thought so far. It's not a human life with the same status as the mother. It's not viewed as an independent entity, but as part of the mother's body. Its moral significance is minimal in early stages, but increases over time. And destruction of a fetus is not a crime, but it is a moral wrong to be avoided and sometimes compensated with damages. For Jewish law authorities, these notions have created a framework under which there is a general prohibition on abortion, unless it is justified for a therapeutic purpose. And the nature and scope of acceptable therapeutic purposes and who gets to decide whether these conditions have been met is where the unanimity among Jewish legal thinkers across denominations starts to break down. A universally accepted justification for abortion is if carrying the pregnancy to term threatens the life of the mother. In that situation, the pregnancy must be terminated in order to save her life at any point in the pregnancy, up until the moment when the baby has substantially passed through the birth canal and taken a first breath. This is based on a passage in Mishnah Ohalot 6:7, which states in quite brutal terms, if a woman suffers hard labor, one cuts up the fetus in her womb and brings it forth member by member, because her life comes before that of the fetus. But if the greater part of the baby has proceeded forth, one may not touch it, for one may not set aside one person's life for that of another. And there are different rationales given for this mandate to save the life of a laboring mother. Rashi in Sanhedrin 72b held that it's permitted to kill the fetus because, prior to birth, as we've discussed, it's not yet a human life. And Maimonides in the Mishnah Torah says it may well be a human life, but he characterized the fetus threatening the life of the mother as a rodef, a pursuer, trying to kill the mother, and she's entitled, and those defending her are entitled to terminate it in order to save her life and defend her. So I want to underline this point. In Jewish law, it's not just permissible, but actually required to terminate a pregnancy to save the mother's life. It's an ethical failure to choose the welfare of the fetus over the life of the mother and thereby cause her death. Her life in being must always take precedence over potential life. And because of this ideal, I think it's clear that Jewish law principles do not align with some situations that have emerged across the US since the Dobbs decision. They would not tolerate the refusal of an abortion to a woman in Kansas who suffered sepsis after a partial miscarriage and was told by 2 hospitals that they could not help her because there was still a fetal heartburn. Or the woman in Oklahoma who had a cancerous molar pregnancy, incompatible with fetal life, who was told to wait in the parking lot of the hospital and come back if and when she was having a heart attack. Application of Jewish law principles might also have saved the life of Savita Halappanavar, the Irish dentist who was allowed to die from sepsis in an Irish hospital because the fetus still had a heartbeat. Her death set off protests that resulted to the 2018 repeal of Ireland's abortion ban. So the Torah and the Talmud are clear that abortion is permissible and required when the life of the mother is at risk. What about when the health of the mother is at risk, either her physical health or her mental health? To answer this, we look both at the Talmud and also at the responsa literature, the centuries of questions that have been posed to rabbis about different difficult situations, a process that continues up to today. When it comes to physical health, abortion has been ruled appropriate in many situations which impair a mother's physical health. Some would limit this to situations in which the harm would be long-lasting, such as causing permanent deafness, while others would permit abortion to alleviate any kind of immediate physical suffering. But halakha, or Jewish law, also recognizes that abortion may be necessary to preserve the pregnant person's psychological health. Many lenient modern rulings explicitly rely on a responsive decision rendered by Rabbi Yaakov Emden, a leading German rabbi of the 18th century. He wrote an important opinion permitting abortion where the pregnancy was the product of adultery to save the mother and child from humiliation and ostracism. But he noted that even in the case of a fetus that was legitimate, not illegitimate, there was room to permit abortion for great need, so long as the birth process has not begun, even if the reason is not to save her life, even if it's only to save her from great mental pain it causes her. And we see the impact of this approach in the view that abortion may be permitted where the fetus has a significant abnormality. It's not because the fetus would have a poor quality of life, but because of the mental anguish carrying the fetus to term might cause the mother. The classic discussion in the contemporary era was what to do about a fetus diagnosed with Tay-Sachs. I think you're aware, it's a genetic disease that afflicts Ashkenazi Jews and causes those to be born to live brief and painful lives. It's now largely disappeared due to the availability of genetic testing for carriers. I know I had it at the time of marriage, and I know Sharon, who's here in the audience, can tell you how you can get access to free and or supportive testing to determine whether you have a Tay-Sachs risk. But in the 1970s, rabbinical opinion on the acceptability of abortion for a fetus who would die tragically or painfully of this disease went both ways. Rav Moshe Feinstein, who was the leading American Orthodox legal mind of the 20th century, forbade such abortions because they did not fall within his reading of the explicit biblical exception that an abortion could only be justified to save the life of the mother. He said, even for children for whom doctors predict a very short lifespan, such as those children who are born with the disease called Tay-Sachs, which through newly developed tests can be diagnosed prenatally, it would be forbidden since there is no danger to the mother and the infant is not a rodef, a threat to her life. One cannot permit an abortion even though there is very great suffering involved. That was one position. On the other hand, a similarly significant ethicist of the time was Rabbi Eliezer Waldenberg, also known as the Tzitz Eliezer, an Israeli legal expert of the same era, and he took a different position, finding that abortion for Tay-Sachs and other conditions that caused great physical or mental suffering to the mother should be permitted even into the third trimester. He said, in the case of a baby who will have Tay-Sachs, one should permit abortion as soon as it becomes evident, without doubt from the test, that indeed such a baby will be born. If indeed we may permit an abortion according to halakha because of great need and because of pain and suffering, it seems that this is the classic case for such permission, and it's irrelevant in what way the pain and suffering is expressed, whether it's physical or psychological. Indeed, psychological suffering is in many ways much greater than the suffering of the flesh. Drawing on this notion of avoidance of great psychological suffering, many rabbis across denominations will permit abortions where the pregnancy has come about through rape or incest, although some may be covert about this and have to be sought out through word of mouth. The conservative movement, however, has been very open about recognizing this as a legitimate justification since the 1980s. In his tshuva, Abortion, Major Wrong or Basic Right, in 1983, Rabbi Daniel Gordis acknowledged, earlier Jewish authorities devote little attention to the problem of women who become pregnant as a result of incest or rape. It will be generally agreed that the victims of such atrocities have already undergone major psychological trauma, even if they did not suffer additional physical violence. To permit such a pregnancy to run its course means to bring into the world a permanent reminder of the terror and shame that the woman experienced at the time the crime was committed. Furthermore, the child would forever bind her to one who had viciously violated the sanctity of her person. So, as I read these texts, there are three important through lines in cases on psychological harm. Abortion is permitted to alleviate anything that might cause great psychological pain to the mother. The pain might flow from dread about continuing the pregnancy, and what is tolerable is subjective, varying from person to person, so it depends on what the woman views as tolerable to her. And indeed, this is the approach shaped by Jewish law that is encoded in the law of the modern state of Israel. This lenient approach, which in effect amounts to pretty free access to abortion, was affirmed by Rabbi Ben Zion Meir Chai Uziel, the Sephardic chief rabbi of Mandatory Palestine from 1939 to 1953, who determined that it's clear that abortion is not permitted without reason. That would be destructive and frustrative of the possibility of life. But for a reason, even if it's a slim reason, such as to prevent her disgrace, we have precedent and authority to permit it. In accordance with an abortion law passed in the Knesset in 1977, abortion is permissible where one of four criteria is met: that the pregnant person is underage, under the age of marriage, or over the age of 40, that the pregnancy is a result of criminal, extramarital, or incestuous relations, that the fetus is likely to have a physical or mental defect, and that the continuation of the pregnancy is likely to endanger the woman's life or cause her physical or mental harm. Deference to the views of the pregnant person about what she finds tolerable emerge even more clearly in liberal interpretations of these sources. Conservative rabbi and bioethicist David Feldman draws an analogy with doctrines on the permissibility of eating on fast days like Yom Kippur. For some people, well, generally it's prohibited to eat on Yom Kippur, but for some people it's a mitzvah to eat, where the fast puts their health at risk. And it's not for third parties, whether physicians or clergy or politicians, to decide this question, but something for the patient herself. He points to the saying in Proverbs, "The heart knoweth its own bitterness," and to the precedent in Talmud that clarifies that we defer to medical experts about who needs to eat, but in the absence of such experts, we rely on people's own assertions that they need to eat. He suggests that similar deference should be offered to pregnant people's views about whether they can carry a pregnancy to term. There are many legitimate ways of reading this material, but I want to focus on two dominant readings, one of which I've already described, saying that Jewish law establishes a general prohibition on abortion, but one that has a wide range of therapeutic exceptions, so wide that, in fact, they swallow the rule, as happens in practice in the State of Israel. It's not difficult to get a letter from your physician who says that there's a psychological need to permit the abortion. But I want to suggest a second reading, which both unifies the material and builds a bridge between Jewish law and the ways in which many Jewish people feel about abortion and make decisions about it in their own lives. On this reading, abortion is a serious matter which engages our deepest religious and personal values, and it's an important decision. It's a decision that many branches of Judaism trust women to make. According to the 2014 Pew Religious Landscape Study, the vast majority of American Jews, some 83%, think abortion should be legal in all or most circumstances, and Jewish women and Jewish clergy have played an important role in the struggle for abortion rights, both before and after the fall of Roe. There have been, so far, over 35 lawsuits brought against states challenging the validity of abortion limits and abortion bans under the Constitution of the United States and constitutions of the individual states. Of these cases, 5 have been brought by Jewish individuals and groups, arguing that restrictive abortion laws violate their freedom to follow the dictates of their religion and the constitutional prohibition on the establishment of a state religion. The most effective arguments thus far have been under state religious freedom restoration acts. The Federal Religious Freedom Restoration Act was passed in 1993 to effectively overturn a Supreme Court decision in Employment Division versus Smith, which held that generally applicable religiously neutral laws did not violate religious freedom if they unintentionally penalized a religious practice. Congress passed the Religious Freedom Restoration Act, or RFRA, to reverse this decision and beef up religious protections, saying that even an unintended infringement upon religious rights is only sustainable if undertaken to achieve a compelling state interest and by the least restrictive means available. Some cases arguing that laws violate the religious freedom rights of Jews under RFRA have been brought by Jewish clergy and congregations, either on their own or in conjunction with clergy of other faiths, whose values permit abortion beyond the limits established under these state laws. In 2 cases that are now combined under the name Congregation Door La Door or Generation to Generation versus DeSantis, several individual rabbis in Florida argue that what was then the 15-week ban is now the 6-week ban in that state, puts them at risk of criminal prosecution for doing their job as Jewish clergy. Their role, they say, is to teach and preach and counsel about what Jewish law has to say about abortion, which is that Jewish law and values recognize no such arbitrary limits on the choice of abortion. And these rabbis claim that they are at risk of being criminally prosecuted for aiding and abetting or counseling an abortion if they simply explain to them what Jewish law has to say and counsel them about their options under Jewish law. Some of these lawsuits are brought by individuals. In Sobel versus Cameron, 3 Jewish women in Kentucky who must use in vitro fertilization in order to have children, either because of infertility or advanced maternal age or vulnerability to genetic diseases like Tay-Sachs, argue that the Kentucky state law, which makes it a crime to destroy embryonic life from the moment of conception, makes it impossible for them to risk even trying to get pregnant. They fear that simply engaging with these reproductive technologies creates a risk of creating embryos who will die or be destroyed, or a risk that they'll be forced to carry a child with a fatal disease to term and watch them die. They argue that under these laws, they're being compelled to follow Christian religious beliefs about fetal life rather than their own Jewish faith. Jewish women in Indiana, in a case called Anonymous Plaintiff versus Indiana Medical Licensing Board, or more popularly known as Hoosier Jews for Choice, are suing because they fear that Indiana's 20-week abortion ban would put their lives at risk if they developed pregnancy complications after that point. They argue that the Indiana abortion ban prevents them from following Jewish law that might permit or require them to have an abortion under those circumstances. And they pleaded that their right to practice their faith is being burdened and that they are avoiding having intercourse or risking becoming pregnant, so they will not be put in a position of having to carry a pregnancy in opposition to their religious beliefs. An important point here is that they're not saying that Jewish law requires that they have an abortion under these circumstances, but that practicing Judaism means that they should be able to deliberate and make these important life decisions in light of their Jewish faith. In Blackman versus State of Missouri, rabbis of all denominations join with Christian clergy to sue the state of Missouri, arguing that it's violating the state constitution's guarantee of separation between church and state. These rabbis attest to the complexity of Jewish approaches to abortion and its inconsistency with Missouri's law, which emphasizes fetal personhood from conception. Rather, they say, Jewish law treats abortion as a complex moral matter affected by halakha and Jewish values like pikuach nefesh, the duty to save lives, and b'tselem Elohim, the notion that we are all created in the image of God. And I want to pause for a minute to parse out how differently the notion that we are created in the image of God, based on the creation story in Genesis, can be deployed in the abortion context. You've probably heard about the recent decision in LePage versus Center for Reproductive Medicine, the Alabama case, in which the Alabama Supreme Court found that a state law that permits wrongful death suits for the death of a child could be used to sue for damages for the death or the destruction of unimplanted frozen embryos created through IVF. This was a situation in which couples had created these frozen embryos. They were stored in an IVF clinic. Somebody broke into the clinic and broke open the freezer and dropped them on the floor, and they were destroyed. And what the court found was these embryos were extra-uterine children, and that their death could be compensated under this statute. And I want to just explore a little about how they got there. The concurring opinion of Justice Parker invokes the notion that we are all created in the image of God to support his ruling. He notes that interpreting the language of the statute must take into account the Alabama Constitution, which includes a 2018 amendment recognizing the sanctity of fetal life from conception. He says that in interpreting what sanctity of life means, we should look at a range of materials including legal and religious texts that provide context and meaning for this enactment of this amendment. And for Alabama, he says, all these texts are Christian interpretations of the Bible. And he concludes, and this is a quote, in summary, the theologically based view of the sanctity of life adopted by the people of Alabama encompasses the following. 1, God made every person in his image. 2, each person, therefore, has a value that far exceeds the ability of human beings to calculate. And 3, human life cannot be wrongfully destroyed without incurring the wrath of a holy God who views the destruction of his image as an affront to himself. The law in question recognizes that this is true of unborn human life no less than it is of all other human life, that even before birth, all human beings bear the image of God, and their lives cannot be destroyed without effacing his glory. Now, this is a legitimate reading of the story of Genesis, holy to Christians and to Jews, but it's not the only reading, and it's not the reading of Jews who favor abortion rights. Compare the way Justice Parker compare Justice Parker's invocation of the notion of being created in the image of God with the way this notion is invoked by liberal Jewish clergy. Here's a quote from Rabbi Rachel Joseph, testifying in support of HB 2002 in Oregon, a statute that would extend protections for reproductive rights. She said, "My religious advocacy around reproductive rights and access to health care is grounded in a careful reading of our sacred and holy texts and tradition. The Torah, the Hebrew Bible, teaches that everyone is created b'tselem Elohim, in the image of God, and therefore each individual body is sacred and holy. Each individual body is autonomous, and no one should be allowed to interfere with my sacred right to self-determination." Or here's a quote from Rabbi Robin Nafshi of Temple Beth Jacob in New Hampshire, arguing that the notion of b'tselem Elohim, that we're created in the image of God, requires us not only to care about the reproductive rights of ourselves and members of our community, but also about the reproductive rights of others. She said, "But if I or we see all people, b'tselem Elohim, created in God's image, then we must move beyond our own zones. We must notice others. We must embrace them. We must care about them. And we must heed the many centuries-old Jewish teaching that demands that people who are pregnant have the ability to terminate their pregnancies when appropriate." Turning the language of Dobbs on its head, in which Justice Alito found that abortion rights were not deeply rooted in American history and tradition, Rabbi Jim Bennett stated in his affidavit in the Blackmun case that giving priority to the life and safety and well-being of the pregnant person is widely accepted in Reform Judaism and deeply rooted in Jewish tradition and scripture. All of these cases are at early stages, with most still preparing for an initial trial. However, in the Indiana case, a judge granted a preliminary injunction against the state, finding that the plaintiffs had a good likelihood of succeeding at trial with their claim that the law violated Indiana's Religious Freedom Restoration Act. They had proven to the judge's satisfaction that the law unduly burdened their rights to practice Judaism by prohibiting them from following Jewish beliefs around abortion. And this is where I had to rewrite this section of my talk because a few hours ago, the Indiana Court of Appeals rendered a decision on an appeal of that injunction. And they decided that the injunction would stay in place, that the plaintiffs had proven that they had a reasonable likelihood of success in demonstrating that their religious freedom was denied and was not going to be found to be justifiable under Indiana's Religious Freedom Restoration Act, that the state could not show a compelling interest and did not use the least restrictive means in achieving that interest. So I look forward to reading that case in detail, but I skimmed the 76 pages on the way here from dinner. But even if these plaintiffs in Indiana and those in other cases are successful, the result may be less than satisfactory. The remedy for violations of Religious Freedom Restoration Acts, both at the state and at the federal level, is not striking down the whole law so that it isn't able to be enforced against anybody. It's only providing an exception to that law for the specific plaintiffs in the case. It carves out an exemption for them, but leaves the law in place to be applied to other people. And this is where it gets strategically and ethically complicated, and we could talk about this in the question period. If this reasoning prevails, it will chip away at the validity of state laws that limit abortion as applied to Jewish people, but would leave the law intact for the vast majority of those affected by it. And as many of the clergy who made statements in these cases and who have put forth amicus briefs in the various cases say, this result does not comport with Jewish values, which want to see the dignity and personal autonomy of all pregnant people recognized, not just those who are Jewish. These cases can also give rise to alarming challenges to Jewish parties' claims. The Indiana case that's now on appeal has several conservative interveners who've argued that the court should not believe that the Jewish patients have a sincere religious belief that is being burdened by the abortion ban. And as far as I can tell, that argument was also rejected by the Court of Appeal. Some argue that the Jewish plaintiffs are insincere because they didn't object to earlier abortion laws that prohibited abortion in some circumstances that Jewish law permits. Others argue that liberal Jews don't feel bound to follow Jewish law anyway, so their desire to do so now is not credible. I think that this gets wrong how most people engage with Jewish sources. Only a small fraction of American Jews identify as Orthodox, something like 8%, and who might be people who would go to a rabbi and ask for an opinion about whether they should proceed with an abortion, seeking a ruling. But many more will turn to Jewish texts and Jewish clergy when they're facing difficult decisions in their lives, when they want to be able to consider those values and consider those principles when they're faced with a particular challenge, and then they want to make up their own mind. So I don't think it's bad faith to turn to Jewish sources when you're facing a difficult decision, as many communities are now facing the prospect of a total ban or effectively a ban on abortion. Jewish women's organizations like the National Council of Jewish Women, traditionally associated with the Reform movement, and the Jewish Orthodox Feminist Alliance are leading current campaigns for reproductive justice post-Dobbs. And as we saw in the statements with which I began this talk, Jews of all denominations, whatever they think about the ethical merits of some abortions, have spoken out against the criminalization of abortion in American secular law. There's a through line connecting this advocacy, these cases, and the rabbinic text that focused on recognizing the mother's subjective experience, ruling that her life might be ruined by disabling health impacts, ruling that her life might be intolerable if she gave birth to a child considered illegitimate under Jewish law and was excluded from the community, and acknowledging that she might find it intolerable to have more children in the future if forced to watch her child to be born and die in her arms. The problem, I think, is that most of these opinions were written by rabbis of prior centuries, including the 20th century, who did not have the direct experience of pregnancy and termination, but relied on their empathic imagination of what women might be going through. They may have shown compassion for the plight of women, but they did not identify with them or their aspirations. As Talmud scholar Professor Ronit Yishai has stated, because the woman is not conceived of in rabbinic texts as an autonomous subject, no interest of hers beyond her continued existence entered into the picture, at least according to the strictest halachic interpretation. No dilemmas are posed with respect to her welfare, the quality of her life, her desire to raise the child, and so forth. But putting the dilemma in these narrow terms excludes the preponderance of struggles over abortion and the bulk of women's experiences. Now, 50 years after the ordination of Sally Priesand as the first American rabbi and the opening of access to higher Jewish learning to women, we now have a chance to see how these texts are read by those with experience of mothering who wish to add their own takes on what this text means. I want to conclude by citing some of these and the promising new readings of Jewish approaches to abortion that they offer. Lou Greenberg, writing from an Orthodox perspective over 30 years ago, struggled to fit women's visions for their own lives into her understanding of halakha. She said, since there are no traditional Jewish precedents for abortion on demand, one way to maintain some integrity within the halachic framework would be to broaden the interpretation of therapeutic abortion, to extend the principle of the precedence of the mother's actual life and health to include serious regard for the quality of life as well. Reform Rabbi Jacqueline Cohen, describing her own abortion decision in 2020, shows how this notion has developed. Rabbi Cohen found out at the 12-week scan that the baby that she was expecting was non-viable, and she described how she used Jewish sources to decide how to proceed. She said, "I chose my life. I chose life, my son's and my husband's lives, our family's collective life. I took the science being offered me and I listened. And as painful as it was, and as heartbroken as I felt, I listened. I recalled my own education from adolescence up through rabbinical school on Judaism's nuanced approach to abortion. While entire denominations, Jewish communities, and religious leaders take varied approaches to the topic of abortion, for a wide majority of us, there exists one universal shared truth. Jewish tradition, my tradition, honors a woman's right to choose. My faith honors my right to choose my future." A 2019 statement by the Women's Rabbinic Network of Reform Rabbis on abortion rights was titled simply, "We Trust Women." It went on to say, "We trust women. The ability God gave to women to carry potential life comes with power and responsibility, and we trust women to carry out the blessings and questions that come with this extraordinary capacity. While not every woman is able to choose to have children, it is nonetheless certain that legislation which diminishes women's rights to choose thereby questions women's ability to be moral, ethical, loving, and thoughtful about life and its potential." I think Cohen's reflection and the Women's Rabbinic Network statement provide a model of how Jewish approaches to reproductive justice continue to be developed as women and people who can become pregnant all bring our insight and experience to bear on these texts. Thank you. So I'm happy to take questions.
So thank you again for coming, and thank you. I really appreciate that. I think the audience does as well, and the audience may have questions, and I invite anyone who has a question to come to this mic because it will be heard clearly on the recording and by the whole room. So I will step aside.
Hi there. So as a transgender Jewish person, I'm incredibly interested in doing the same kind of parallels between Jewish research and gender studies research that you do. I gotta admit, I'm not thrilled at the idea of getting 3 law degrees. And so I guess I'm kind of wondering, like, if I want to do what you do, and it seems like there are precious few organizations in the world that do what you do, how do I do it?
Let me put it this way. There's a lot of interesting and exciting work being done in Jewish studies on trans sort of aspects of Jewish tradition. Max Strassfeld has a great book called Trans Talmud, and they are a rabbinic scholar and look back at all the texts in which trans and non-binary people are discussed in the Talmud, and offer a reading of what that meant at the time and how it might be deployed in interesting ways today. And that's just an example of sort of a wide literature. You can come take courses. You can take courses at Brandeis, but maybe you could take courses here. It's possible to do this work in the context of Jewish studies, in women's and gender studies, in the study of Talmud, the study of Bible. Somebody else who does wonderful work from a trans perspective is Joy Layden, whose book that we actually published in our series at Brandeis University Press. It's called The Soul of the Stranger, Reading God and Torah from a Transgender Perspective, in which she reads Torah and reads the story of Genesis and other stories with a view to exploring how gender is constructed in time, that gender is not something that exists primordially, but is sort of created as part of the creation story, and how she as a trans person kind of identified with God as a disembodied person, or a person whose body didn't sort of match her identity when she was growing up. So lots of interesting stuff out there. I'm happy to give you some more suggestions.
Awesome. Thank you so much.
has cited a great number of scholars and a great range of views from the Orthodox to the Reform about Jewish law, and your lecture was about Jewish law. Has contemporary Jewish law, any particular rabbi or person engaged in a consideration of the details of modern embryology? Does that matter to Jewish law about abortion?
So that's not something that I have expertise in. I think there's people who do reproductive ethics, but it's not something that I can comment on.
I think the facts were that under the common law, abortion was, well, that American and state by state, I would say the 20th century and late 19th century, restricting abortion more and more was based on the discoveries of modern biology. And so the details of the developing fetus was considered a matter of legal importance. But anyway, I'm just wondering, you didn't cite anybody who's considered modern biology, so.
No, that was not a focus of my talk.
Hi. So given your background in law, what do you think is the likely outcome of these lawsuits that have been brought upon different states and organizations?
So if you had asked me earlier today, I would have said, I think there's a good chance that the Indiana case will be successful, and so far the Indiana case has been successful. So I think there is some likelihood that these Religious Freedom Restoration Act cases in different states will have some effect. They have only a partial effect. You know, as I said, they sort of chip away at the applicability of the law against certain people. Ultimately, that may have a salutary effect, if that's your objective, in ultimately undermining the law by peeling away more and more populations to which it does not apply. It's unclear whether that will have a wider impact. And I don't think we can look to the courts if your objective is to secure reproductive rights. Looking to the courts can't be the only strategy. I think there needs to be legislation that protects abortion rights.
And you said that a lot of these lawsuits were brought up by, what was it, the Religious Freedom Reformation Act? Restoration Act. Are there cases that are not brought up under that act?
All the cases are generally arguing multiple challenges. So they also argue sort of general religious freedom. And so they argue that Jews' free exercise is being interfered with, and also that, depending on the state, that the state constitution's guarantee of a separation between church and state is being violated. But those cases are all at very early stages. There's been no judgment from the courts. It's just in briefs argued by the parties, and there's no sense of what the court thinks of those arguments.
Okay, thank you.
Hi, thank you for your talk. It was really interesting. I noticed when you were talking way at the beginning about the direction that's provided, I can't actually remember which text it's in, but around the difference between causing a miscarriage by assaulting a pregnant person and the other harm that's done by potentially injuring or killing that person. That on the one hand, that does seem to provide some clear kind of rationale for an opinion about, abortion perhaps, or the life of a fetus not being treated the same way, or even not being treated as a life. But on the other hand, it kind of goes on to say that if the pregnant person is killed, then the life for a life rule applies. So I guess I'm not even sure what the question is, but there was some kind of schism there for me, because it's like, how can potentially a legal scholar or even just an ordinary Jewish person invest themselves in a law or a ruling or a decision, I'm not sure exactly what to call it, that provides some guidance in regards to one thing that seems appropriate, and perhaps by contemporary Jewish cultural standards in regards to this other thing seems completely out of line. Do you know what I'm saying?
Well, which is which in your analysis? Which is the
Right,
thing that,
well,
which is
but-
appropriate and which is out of line?
Right. Well, regardless, for me personally, I'm not saying for other, for Jewish legal scholars or for anyone else, that capital punishment is something that's, not acceptable, not morally acceptable. And so, and I imagine, though I don't actually know the statistics on this, that there are many, there's a large proportion of the Jewish population, at least in the United States, that feels similarly. Don't know if that's true or not. So I guess that's kind of what I'm commenting on. Okay. Yeah.
I know, I get what you're saying. So that's a passage in the Bible, in the Torah, and it's not applied to solve problems. It's the basis on which centuries of rabbinic commentary has been built. So that's the initial text, and then they've been working on that and offering different opinions. Well, what does it mean in this situation? What does it mean in that situation? Up until the present day, where we're still trying to both look at that primary text, but also the centuries of interpretation in order to come to our own conclusions. So yes, we can move very far away from the vision of life that and the vision of what's appropriate in that text to applying it to solve problems in the present day. It's a piece of the puzzle. It's not something that on its own can solve the puzzle, but it's an important part of the history of Jewish approaches to understand that that's where we started from.
Right. No, I got that. Just kind of about the, for, say, a contemporary Jew, understanding that that is part of what the underpinning is for the Jewish legal perspective on it. How do we reconcile these different aspects of that, that foundation, when there are perhaps other aspects of that very same situation that, that really don't seem to resonate for some of us anymore. Yeah, thanks.
So, what you've said is we have singled out Jewish people to be, questioning these abortion rights. But would it be more effective if it was sort of a coalition of different people bringing these kind of challenges to the law? And if that's the case, why aren't we doing that?
So I didn't talk about all the parties. So for example, in the Missouri case, that is a collective case. So there are a number of rabbis, as an imam, there are clergy from various Christian denominations that also affirm abortion rights. So I was highlighting the Jewish parties, but in many of these cases, either the parties are an interfaith group, or there are amicus briefs filed by other religious groups in support of the similar argument.
So, okay, then I would ask, now they're making it a religious issue, but would there be other kind of a coalition that would make it bigger? Because my understanding is most people are against these abortion restrictions. Yeah. So, how could they make it more powerful, rather than just singling out these things as religious issues? But everybody gets together and challenges.
In many of these states, these are not the only challenges. So in Indiana, for example, there was another challenge, just a straight-on challenge being brought based on reproductive rights claims, not using religious arguments. This is a parallel approach, not an alternative approach. And you're right. It's it's innovative, and it hasn't been successful in the past, and it's interesting to see whether it will be successful in this situation and what the follow-on effects are. What does it mean to have Jews play a central role in making these kind of claims?
Because at this moment, we're looking at this from a Jewish perspective, but it's not just a Jewish perspective. So what about the Freedom of Religious Act? How about we start really fighting for the divisions, government of church and state, and how about fighting for religious freedoms and that we can practice our religion as we see and believe?
Yeah, I think that is part of this approach. Both Jewish parties making those kind of arguments and other parties from other Christian denominations and other religions making those kind of claims.
They have joined in some of them, but is anybody doing it independently? Is there anything about the Freedom of Religion Act being done independently towards abortion rights?
Well, you'd have to invoke some kind of religion that was at stake in order to make a religious freedom claim.
Gotcha. Okay, that makes sense.
You'd have to
And by the
mention
way-
something.
And by the way, trust women was the best comment out there.
It's actually a bumper sticker I have on my car.
So I call the question, seeing no debate. Oh, sorry, that was earlier. That was a faculty senate. Let's thank Dr. Jaffe again for a wonderful presentation and for addressing the questions. If you don't live in South Carolina or you don't mind driving back next week, we are going to be having just outside this door, Hate Ends Now, a unique exhibit on the Holocaust. It's a replica of a cattle car used to transport Jews to concentration camps, and it's an immersive 360-degree event, an experience, and there'll be opportunities, as you see these little flyers, where you can register ahead of time, although you can also just, you don't have to be registered to go. But if you're in a group or you have limited time, you may want to register. And let's thank Dr. Jaffe again. And I want to thank everybody for coming out tonight. Thank you so much.